Guys, we are live with Ron Zambrano to react to his thoughts on Judge Lyman's full ruling, but also this latest attempt for Blake Lively to demand to know Justin's witnesses before hers. Is this allowed? Let's discuss. Welcome to Popcorn Planet. I am Andy Signore. Like I said, we are live, and I'm so glad Ron Zambrano is back on his vacation, no less. Give a huge round of applause to him and his family for letting him take away these 10 minutes to help talk to you. We always appreciate you making the time, sir. Let's get into it. So you had a chance to look more at some of the reportings and Judges Lyman's rulings. Any other big takeaways that you haven't shared yet or surprises based on this verdict? And do you still think it's a big win for Justin?
I think it's, that hasn't changed. And there's been more detail that I've been able to read as to how short the Lively fell from the standard for harassment, which we kind of were leading into anyway. Like, how can that be harassment? How could that be harassment? But it's in writing now from a federal judge that a lot of people were saying that, that Lyman was bending over backwards for Lively, or Ryan Reynolds. And I understand why they thought that, but justice is slow, unfortunately, especially under our judicial system, but they typically try to get things right. And I think he got it right. And it's pretty brutal reading for Lively on that end.
Now, she's spinning this as a win, right? Her team's out there. The last thing I wanted in my life was a lawsuit. It's so hard to read that with a straight face. When she had every choice of the way to make this the lawsuit. I brought this case because of that pervasive retaliation I faced and continue to for privately and professionally asking for a safe working environment for myself and others. I want your reaction to that, Ron, because when we first met and you interviewed for the documentary, you said something that made our trailer even, which was like, if anybody was not getting what they wanted, it was Justin. Blake Lively got every single thing she asked for. She complained, 16 days into production. She complained, she got every demand met. And then she's admitted on the record in her own complaints that she had a very professional, fantastic second phase of shooting and everything went okay. So I'm confused. Do you believe this, that she's saying that was always the intent? And do you really think she's going to be able to fight this idea that it was an unsafe working environment?
No, I've always thought the biggest problem for her, I agree with everything you've said, right? Like what is in the record, what she's admitted, how long it was, and what's contemporaneous writing. Like contemporaneous emails and text messages are so revealing. And I think juries and people like us and judges really care more about what you said at the time than what you're explaining now. But I really think what most people, at least I reacted to the most, was how much she imposed herself leading up and through the premiere. How Justin was made to, wait, in the basement or the lower floor for his own premiere. I think the idea that she was somehow, I don't want to use the words submissive or subservient to, Justin or Wayfair Productions in any way she can argue with any credibility. And I think that's her biggest problem, right? From the facts alone, she doesn't come off as a victim, like someone's trying to keep her down, she was being repressed or oppressed. None of that comes through with the reality. And I think that is her biggest problem at trial. It'll be her biggest problem at trial. Because if she's going to try to say, listen, I tried to do this and they shut me down. I tried to do that and they shut me down. And I'm just a woman and, poor old me. That's a good narrative, but that's not reality, which has been well reported. God knows how this is going to come out of trial.
Well, it's not just even Blake. I brought this up because we're working on another story to talk about sort of the spin and WME and everybody supporting, but Ryan's own emails and text messages are also incredibly damning to show sort of the puppet master, if you will, and sort of the whole plan. Like reading these, and we've reported on these ages ago, but even just him telling his agents that, all the cast unfollowed her. But then we go back and realize in depositions, it was Blake that asked them to unfollow him. So all this stuff, the more nitty gritty you get into, I'll call it gaslighting. I feel like we constantly are seeing here from Ryan and Blake and their power moves to try to rewrite and manipulate the narrative. How much of that do you think is going to come into this play as they're now arguing over the smear campaign?
Oh, it'll absolutely, all of it will come in. And that's why we take depositions. Like a lot of people are annoyed or think it's a lot of work. It's worth taking the depositions because you never know what people are going to say. And you never know, people like, oh yeah, I was asked to do that. Oh yeah, I told them to do that. Oh yeah, that's because of this other document that you just learned about. And it's like these dots get created that you didn't know happened, and you follow the dots to the real motive, and it's consistent with the overall narrative of there's this power play from a person like Ryan Reynolds is trying to have his wife Blake Lively also do the power play, and it's just reconstructing itself and regurgitating itself. And I mean that's what it is. Again, it's hard for her to be in that colored in, let's call it colored in that shade of gray of, well, yeah, I'm a female, but I'm also part of this more powerful brand that is Ryan Reynolds, and then try to also be like, well, I am also the victim, when it just doesn't, it doesn't pass the smell test for her. And I don't think she'll do well at trial because of that.
Okay, now there's two things that she could still lose, I guess. I want to go through them now. So in the main document, as Kim was prepping this for me, I'm going to read it because it's a little bit complicated, but hopefully you can explain what we're getting at. Obviously, 10 of the 13 cases dismissed. 3 of them survive. Those are 3 of the FIHA retaliation claims against It Ends With Us movie, Wayfair, aiding and abetting the FIHA retaliation claims against TAG, and the breach of contract rider agreement against It Ends With Us movie. Now, the TAG claim in count 7 is one that's still in jeopardy because apparently the judge was candid in it about why he didn't rule on it the first time. The legal question whether a third-party business entity like PR firm can be held liable for aiding and abetting FIHA retaliation is genuinely unsettled. The California Supreme Court explicitly left that question open in Raines versus U.S. HealthWorks. So TAG gets to come back with a focused brief arguing exactly that even if FIHA retaliation happened, TAG, the outside PR firm, cannot legally be on the hook for aiding and abetting. The judge has ruled that if TAG renews its motion for summary judgment, any such motion shall be filed with the parties' pretrial filings on April 10th, which is in a few days, and then plaintiff's response should be due at the same time on the 17th. So thank you, Kim, for that bravo explanation. Quickly, can you explain what that means and what do you think is going to happen? What is that?
Right. So there's a lot of moving parts here. So Raines v. U.S. HealthWorks is a really huge California decision where I'll briefly explain it. A lot of people that work regular jobs know this. There are third parties outside of your employer that regulate, your attempts to take a pregnancy leave or medical leave, and there are third parties that do screenings on behalf of the employer. Well, guess what? Those third parties are basically acting as an extension of the employer. They decide whether you can take your leave. They decide whether you met your qualifications physically to do the job. So they're kind of an extension, what we call an agent of these employers. So what the Supreme Court said in Raines was, these third parties, yes, they're not really the quote unquote employer, but they've been designated to do what's called FIHA regulated activities. Basically, they make the decision whether or not you can be accommodated for disability. These third parties are the ones who make these decisions whether your medical leave or your pregnancy leave qualifies under FMLA and is protected or not. These third parties, and because of that, these third parties can be sued under the Fair Employment and Housing Act under a theory of aiding and abetting. And that's the rule in Raines. So it really expanded for us California attorneys of who can be sued other than the employer, which I think is fair because what the employers were doing is like, well, it wasn't us. We just hired these people and you can't come after us because it's their decision. And we're like, no. You guys are acting and together and you discriminated against my employee who happens to have the audacity of getting pregnant. Oh my God. And you fired her. So now let's come here. Is TAG a entity of Wayfair that is doing FIHA regulated activities? And the judge is saying probably not under Raines, right? They're not a screening for a job kind of folks. They're not really regulating leaves. They're not really regulating whether or not accommodations are being done. They don't really fit into Raines. And the judge has invited TAG to make that argument so that it's a clean summary order dismissing the claim. You never. I've had this happen to me.
It does seem like he's sort of queuing him up. Like, you missed this. If you file this, you're going to get off. Is that how? Am I reading that correctly?
Yes, and I've had that done to me before, and it's one of the most frightening things as a plaintiff when a federal judge asks the defendant, "Hey, on this very specific issue, can you write a motion to dismiss that claim?" That is frightening, and you never want to do it. You never want to be in that position.
Yeah, this is Blake Lively's case, and the judge literally just teed up for Justin and TAG, who may be sweating right now. Oh crap, we're screwed. He basically is like, no, you got a week, fix that, And then I'll probably toss it. But Blake, you can respond, whatever. But it sure
Right.
seems like he's he's reading the room. No,
100%. 100% he's reading the room. Again, judges are the gatekeepers of what goes to the jury. That's what a motion for summary judgment was. And they're gatekeepers of like, well, is this going to be a waste of time for me presiding over the jurors? Is it going to be a waste of time to them? And again, this tells you how much he knows the law, right? He's really like, I know rights, and I can't really do it here from a due process standpoint, but I'm gonna set it up like you're teeing it up for, hey, wink, wink, tag, do this thing that I'm telling you how to do, and here's your roadmap to do it, because chances are I'm going to grant it. And I'm assuming tag is working, right now doing that.
Right, and that would eliminate Tag and Melissa. Then they're fully gone. It's then only on It Ends With Us movie and the Wayfair Productions, which is the last two sort of entities allowed. But for most, and you were even saying before, I think it was Greg, I guess you both, Tag could be at jeopardy, but now with this sort of unclaimed ruling yet, maybe actually they are going to get away with this as well, it sounds.
Yeah, absolutely. They would absolutely get away with it. And even if they weren't, let's
get away with it, maybe a wrong word, but not dismissed.
They wouldn't be dismissed on the technicality, but the thing is, the judge is going to, I think what the judge says is the jury, even if we would go to the jury would never see it. Like, that's the argument, right? They were just like, we would never see it. It's not even something they would even consider. It's a waste of the jury's time. It's a waste of trial time. So let's just do it cleanly. I'm not extending the trial date, but I'm going to give you guys a new briefing schedule for purposes of due process for Lively, so that she doesn't, say like, well, Your Honor, you're doing this on your own. You just, because technically the federal judge, or any judge, at least in California and in the federal system, can rule that there's no tribal issue of fact, even if it wasn't brought up by a party, although you always run the risk of getting overturned or appeal. This is the cleanest way for the judge to do it, going like, I'm going to give you the issue, tag, go file a motion for summary judgment, come back, chances are I'm going to grant it.
So that's fascinating, because then that would be 11 out of 13 dismissed, leaving her with 2. How much more does that leave her wanting to attempt to actually settle this? And what is your reaction as we see the last minute talks with the magistrate yesterday were wrapped up, and apparently both sides are refusing to settle?
Baldoni or Wayfair, I'm assuming, I think Baldoni is a principal of Wayfair. They have all the leverage. The claims that survived are weak, and they don't, get the juices flowing as far as opening statement. A jury's really not going to. It just isn't something that Lively should land on. I'm making a presumption, speculation, and conjecture. Lively's going to the table. Please, let's settle this. And Wayfair is going like, no, like, you made your bed. You started this with the New York Times article on something that should never been done. And now here's your medicine. That's what I think is happening.
And then who's on the hook to pay? Like, because his got dismissed as well against the New York Times, then against Blake, right? And now if Blake's are all dismissed, or in a court of law dismissed officially, who's then on the hook for paying these bills?
Well, that's a great question. So without the FEHA claim, on the claims that survive, well, let me back up. Most people don't know that when you sue someone in California and in New York, I could say this because I've done cases in New York through limited permission. If you're the plaintiff and you lose, normally you owe the other side's costs, not their attorney time, the costs, filing fee, if there was a deposition, whatever it is. It can range from $2,000 to $20,000. You're on the hook if you lose, okay? There's an exception to this, and it's called the Fair Employment and Housing in California. And if you lose as a plaintiff on your claim, like Lively is now, let's suppose she loses it, she doesn't even owe costs, and she can never owe fees for Baldoni, unless the judge says it was a frivolous claim to begin with. She knew from the beginning it should not have been done. And this one, I give it 50-50, right? I give it some of the claims, talking about circumcision, should she have brought that claim? Was that frivolous? That is the risk for her. Will she ever owe attorney time? Probably not, but she could owe costs, and costs must be well over the 6 figures. How much that is to her and her husband? Probably not a lot, but I would not want a $150,000 cost bill going my way. And here, because of how flimsy the sexual harassment claims were, I would be concerned that Judge Lyman might go, this might fit the exception to not having to pay costs.
Right.
Other than that, Andy, the answer is everybody goes with their own fee bill. And
right.
and,
I assume that's exactly. But now, so Justin, again, more incentivized to keep this going, to potentially get the loss, to then get the frivolous claim because of her case. Interesting. One more thing before you go, I want to get your thoughts on this new document that came in this morning about demanding the witness list. What is this typical? Is this standard? Who has to share their witnesses first? Because clearly that's an advantage, I would imagine, right? Shouldn't they both have to just drop them the same day or something?
Yeah.
What is this request?
So this is very interesting in the sense of how federal cases go. So federal cases, from the beginning of the lawsuit, Andy, you have to disclose your witnesses that you anticipate having to go to trial. It has to be a very detailed list, the names, how you get in contact with them. If it's not through the attorney, and what you think they know. You have to list them. And if they're not on that list, you cannot really add them later. So what's interesting here is that there's supposed to be a final witness list. And there are people that are listed in the Rule 26. This is called the Rule 26 disclosure. These initial lists that apparently are being withheld in the final witness list that, you are correct, should be submitted at the same time. And the importance of this is this. When you're preparing for trial, and this is why it takes so long, if you know that there's an adverse witness, well, it's Justin Baldoni, like that's being contemplated in this letter. Justin Baldoni is going to be called as a witness adversely. You can go and designate portions of Baldoni's deposition transcript so that you can use the deposition at trial. And that's a lot of work, as you can imagine. And you can also use the video. So you have to find the transcript, and you have to find the portion of the video that matches the transcript, and you have to designate those portions that you want to use because you think they're, juicy and compelling to a jury, and put it all on paper and then submit it within a deadline to the judge, because if you don't do it on time, the judge won't let you use that deposition testimony. So this is kind of like what we call slow walking it, kind of making it difficult. But I think Judge Lyman will ultimately tell the Baldoni folks and the Wayfarer folks, listen, don't mess around with the witness list. I don't like this. That has nothing to do with the rulings on the substance. This is a procedural thing. If I have to get mad at you or delay things because of you, it's going to go wrong for you. That's my anticipation what's going to happen. But that's what this contemplates.
And how likely do you think it is that Taylor Swift becomes a witness? And if she's on her wedding and doesn't want to come, can they force her?
Yes, they can. They can force her. This is how much the federal system, federal judges don't care what you are, who you are. They will treat everybody the same.
Right, because I was didn't interrupt, but like in the Depp trial, like Elon Musk, James Franco, they weren't, but that wasn't a federal trial. That was a civil case. So therefore, in federal, it's different. If they put Taylor Swift on that, it doesn't matter if she's got her wedding. The federal court can say, you need to be here on this day, and she has to drop what she's doing and show up on that day.
Yes, remotely, if anything. Absolutely. Because in the federal system, the jurisdiction of the courts is so much wider than the states. Right, everybody's subject to a federal law. So absolutely, if Taylor Swift is there and you want her to appear as a witness on your terms, then you have to, one, serve her a subpoena as a third-party witness. Have fun with that, and then two, coordinate when you think she's going to happen. I mean, this is the work of trial, Andy. Let's suppose they're going to start in May or whatever, but you don't know the order of things, how long voir dire is going to be. Are you going to be there day 3, day 4, day 5? That's what you have to coordinate with these witnesses, and hopefully they're available. And if they're not available, just like, sorry, you lost that witness. They're not available unless you want me to order them to be available another day. But you have to do that well before the trial starts. So, being a trial attorney is a lot of stress. Is the witness going to show up? What are they going to say if they do show up? Are they going to show up remotely? Did I ask permission before they can do that? Because the judge is going to be like, sorry, you didn't ask. They can't come in. Who's your next witness? Oh, you don't have anybody available now? Okay, I guess you're resting. That's the stakes that are involved at this point. And that's why I could see why this letter, they're taking this seriously. I don't think this is a request that is frivolous like we have seen otherwise.
How likely is it that Wayfair and Swift's team are speaking privately to avoid that and potentially getting messages on record, or anybody else or any other celebrity or things that are happening? Is that something you think that's happening pretty fast right now?
In the sense of coordinating witnesses to show up at trial?
Yeah, well, I mean, because we know there's this alleged thing that Blake told Taylor to delete the text messages, and allegedly Taylor Swift's dad was the one who told Friedman, right? And I would imagine, why would you not bring that to the trial when you're being alleged of deleting your signal chats and all this other stuff that they are?
Right.
That seems like a piece of evidence, if it's real, to use at trial, no? So is there negotiation tactics you think happening with some of these Hollywood players to try to avoid Taylor being deposed, to get an official statement that gives them the ammo they need? Do you think those types of negotiations are currently happening?
No, because if Taylor doesn't show up from the Wayfarer's perspective, if Wayfarer doesn't show up, it doesn't matter what she puts in writing. If it's not said in court, it doesn't get heard by the jury. The jury can't read a declaration unless there's a stipulation by both sides of what she says. So,
oh, interesting.
Everybody knows the word hearsay, right? But hearsay, I think, there's good things and bad things about it. But a declaration, let's suppose Wayfarer have a declaration that they have the dad sign or Taylor herself sign, right? Unless it's stipulated by the Lively team that they could use it at trial in lieu of live testimony, it will not come in, even if you sign it under penalty of perjury, because of the hearsay rule. And we could talk hours about the hearsay rule. So that's the importance. So if she being Taylor Swift or Taylor Swift's dad is subpoenaed to come in, any negotiations have to include a buy-in by the Lively folks of what can be read into the record in lieu of live testimony. And I don't think they're going to come to an agreement. They being Lively and Baldoni or Wayfarer are going to come to an agreement of the bad things that they're going to say, right? They're like that. So she has to come live, or any of her testimony,
or remotely. She could do it
even
over
her
Zoom.
Documents. Yeah, this is how technical it is. Even the text messages. Let's suppose there's text messages between Lively and Taylor Swift. Taylor Swift's responses, some of those won't even come into the record. It really depends on the context. Like, that's how technical it's going to be at trial. So if it's really important for Wayfarer, for Taylor Swift's text messages to come in, she has to show up to say, those are mine, I said them, and this is, I said them, and I'm here to repeat what I said. Otherwise, they don't come in.
Amazing analysis. I don't want to keep you any longer, but just final thought, as I always have with you. Okay. What do you think is going to happen? Do you think because Justin's got so much control, this really is going to go to trial? What's your final guess now?
I imagine that this is what I really imagine. The Wayfarer parties have so much leverage that they're probably making demands of the Lively team that Lively will never do, right? Things that would make her, eat crow in a very embarrassing way. And it's just something I think that's what they're demanding. And I think they're doing it on purpose, because a win a victory for the Wayfarer at court is so big, and I think so likely now because of what the judge has done and is asking TAG to do, that there's really no incentive for compromise on Wayfarer's part. So that's what I think is going to happen. And I think trial is very likely going to happen unless Lively goes, I'm dismissing this without a settlement, and whatever goes. And that's a possibility, right?
What does that mean? So she can just dismiss it without any penalty?
Well, I don't think she could dismiss it without any penalty. She could dismiss it with the risk of maybe being found frivolous and she owes money to the other side.
That's even worse than losing in court, especially when she's like, I will see you at trial.
But think about it. I mean, really, really zoom out, right? What's worse, her tanking a live testimony over the course of 3 or 4 weeks and her case is getting worse? Or she files something, dismisses everything, she has to pay $4 or $5 million. What's worse? What's worse for her, right? And that's the conversation that I think is happening now with her. I think going through trial is worse. I think going through trial and things coming out, and Taylor maybe coming or not coming, God knows, Abel coming, and all that stuff coming out. All that stuff coming out, is that worse than dismiss it and see what the fee bill is? What's worse?
That's the question. Always appreciate you, sir. Always grateful for your insight.
Of course.
Thank you, Ron. Enjoy the rest of your time over there. We appreciate you so much. Stay tuned. We got a lot more coming your way regarding this and so much more.